Hi everyone, my name is Timo Becker. I'm a German-American attorney and I'm based in Miami, Florida. I specialize in international tax law, business and corporate law, and business immigration. Today let me talk a little bit about the E-2 Treaty Investor Visa. The E-2 visa is probably the most popular visa for foreign entrepreneurs coming to the US. It is a non-immigrant visa, but it can be extended indefinitely. So I have clients who stay on that visa here or have been staying on that visa for 20 years plus. So it is very popular because your spouse and your children under 21 years can come to the US, and you do not have to invest $1 million, for example, in order to obtain a green card and go the EB-5 route, for example. So it's very popular for smaller investors and a very flexible visa. So let me explain a little bit about the requirements for obtaining an E-2 visa. So you can read a lot about the requirements on the internet. There are many YouTube channels that explain everything in great detail. But it is not a totality of circumstances test. There are certain requirements that are stated in the Foreign Affairs Manual. That is, those are the rules that the consular officer will use and apply in order to determine if you qualify for an E-2 investor visa. So there are basically 9 requirements that you have to fulfill. First, of course, it is a treaty visa that is based on treaties that the United States has with certain countries. Most industrialized countries in the world have such treaties with the US. So that's the first requirement. The second requirement is that the applicant or the business that applies for the E-2 visa has to have the nationality of the treaty country. The third requirement is that the applicant has already invested or is in the process of investing in the United States, in a business in the United States. Then number 4, the business or the enterprise is a real and operating commercial enterprise. Fifth, the applicant's investment is substantial. Sixth, the enterprise is more than just marginal, only solely for earning a living. 7, the applicant is in a position to develop and direct the enterprise in the US. 8th, the applicant is in an executive or supervisory position or possesses certain skills that are essential for the business in the United States. 9th, the applicant intends to depart from the United States once his visa status terminates. Okay, so let me go into a little bit more detail about the requirements. Let's start with the first 2 requirements, first treaty and the nationality of the applicant. So here we have the 50% rule. That means that in a business where, let's say, there are multiple owners, at least 50% of the owners of that business that applies for the visa have to have the nationality of the country the applicant is coming from. Then, if we have a dual nationality of applicants, well, for example, you're German and you are Italian or Brazilian, you have to really decide what nationality under you are applying for. So usually people also apply through the consulate or embassy in a foreign country. So whenever you apply with your citizenship, you have to technically go to that country and apply through that embassy or consulate. Another important thing is that if you are a lawful permanent resident, for example, you cannot at the same time apply for an E-2 investor visa. Let's say to send an essential employee over to the US. So that's also a very important requirement. On the other hand, you can be in a partnership with US partners in the US enterprise, but you have to make sure that you fulfill the 50% rule, and the majority of owners of the business that qualifies for the E-2 visa have to have the nationality under which you're applying. Okay, let me talk about the third requirement. The applicant has already invested, or is actively in the process of investing into a U.S. enterprise. What does that mean, basically? First of all, the investment has to be at risk. So there must be the risk that the investor will lose his money if the enterprise fails. Second, the funds must be irrevocably committed, which means that the investor is not able to retrieve those funds anymore or pull back his investment. In a lot of cases where the applicant buys an existing business, the contract, the sales and purchase contract of the business can be contingent on obtaining an E-2 visa, which the consulate will see as permissible, so that you can show basically that the funds are irrevocably committed. So investment, what does it actually mean? Where do you can invest in? What counts towards your investment? Certain things here, of course, if you buy goods and equipment for your business, then you have already purchased those and are committed to the business. Also, payments for lease and rents can be maybe sometimes included, and intangible property, some trademarks or franchising rights, for example, they can also be an investment where you invested in that enterprise. Number 4, the enterprise is a real and operating commercial enterprise. What does that mean? Active, it cannot be a passive investment. So you cannot only, let's say, wire money in your corporate bank account in the US and let the money sit there. No, the money has to be invested either in goods or in an active business that is basically operational and active. It cannot be only a paper organization. There has to be, you have to offer services or sell goods actively in a business. So mere speculative businesses, let's say you buy some stock in a company and you have a portfolio, that won't count as a real operating business. Also, if you buy a vacation home in the US, a lot of my clients buy vacation homes in Florida, and they always ask me, can't we apply for an E-2 visa? There are certain ways of investing in real estate and applying for an E-2 visa, but a general family home won't do. So requirement number 5, the applicant's investment has to be substantial. Well, this is one of the most complicated requirements in the whole E-2 investor visa process, and because it's not clearly defined what a substantial investment is. There's no set dollar amount. Most attorneys will tell you an investment of 100 or to 150,000 is a probably quite safe application. But a lot of applicants have invested less and also received the visa. So it is, each and every case has to be looked at individually, and for each and every investment, the question is, what do we need to make the enterprise operational? Or the easiest way is, if you already buy an operational enterprise, an existing enterprise, the investment would usually be sufficient if you purchase that business with it. So the 6th requirement, the enterprise is more than a marginal one solely for earning a living. That's the marginality test, which basically means the investment has to create so much income that beyond the living cost of the applicant and his family, there is a contribution to the US economy. A lot of times this can be evidenced through hiring a full-time US employee, for example. It is not a requirement technically under the law that you hire someone, but it is recommended because it shows your contribution to the US economy. Basically, under the Trump administration in 2017, consular officers were basically advised by the White House to interpret the rules in such a way that the investment has to create jobs in the U.S. This is still basically an unwritten requirement. It is not necessarily required to hire an employee, a W-2 employee. You can also maybe hire independent contractors and show your contribution to the U.S. economy beyond your living expenses. So requirement number 7, the applicant is in a position to develop and direct the enterprise in the U.S. Here again, we have the 50% rule, which basically means if there are more than one owner of the business, then the applicant has to have at least 50% interest in the business. Usually, I would recommend 51 if possible, but 50-50 usually is sufficient. It has to be a controlling interest. And the applicant has to be able to develop and direct the business in the U.S., which also means that management control is beneficial. If you really are a president in the company or a director, for example, you can really make management decisions, which is very important for the application to succeed. Requirement number 8. The applicant has to be either an executive or an essential employee with a special skill set that is necessary in the business in the US. An executive is someone who is in the organizational structure of the business, someone who can make managerial decisions, major business decisions in the business. An essential employee is one that possesses specialized skills that are crucial for the success of the business in the US, either through experience or prior work experience or a special skill set, engineering degrees, etc., etc. So last but not least, requirement number 9, the applicant intends to depart the United States when the E-2 status expires or terminates. The E-2 visa is a non-immigrant visa, so you basically have to have the intent to return to your home country or leave the United States once the visa expires. Let me clarify one of the most common myth about the E-2 visa. You do not have to show that you retain a residence or a home in your home country in order to show this intent to return. So you can give up everything in Germany or Austria or Switzerland, for example, sell your house, terminate your lease, and then really move to the United States. The only thing is that you have to have the intent to return.